the law as it relates to non-compete, non-solicit, non-recruitment provisions. I'm going to focus my discussion on I keep calling it the new law. I guess it's not so new anymore, but on the law that was passed in 2011. Unfortunately, because we still don't have any substantive decisions from any of the appellate courts in Georgia relating to the statute, if you've heard this presentation before, it's going to sound a lot like it has in the past. But hopefully for those who haven't heard it before, it'll be informative and try to break the statute down in terms of how it works and how it applies in various situations. The new law is not retroactive, as most people know, so we have maintained the old law in the materials. I'm not going to really spend much time on the old law, but you can review them, and they're a great resource if you have any questions or any issues that arise under the new law. I noticed that Aaron Chosmer is here today. I'll give him a shout out for having worked on those materials back in the day. We've just tried to keep them going and update them as decisions come out. And as you all know, there's still decisions coming from the Court of Appeals and the Supreme Court on agreements that are governed by the old law. Really, most of the most significant reported decisions under the old law during the last couple of years have related to procedural issues like venue selection clauses and things of that nature. So I'm going to leave that to Tom Gallo to talk about. I think that one thing that always strikes me about the new statute is that the proponents of it said that they thought that it would lead to predictability, and at least in my experience, it's been anything but. I think that the new statute leaves as many questions unanswered as it answers, and also leaves so much discretion to the judges that the outcome of any TRO hearing, any preliminary injunction hearing, or even ultimately the case depends so much on the individual judge that you draw. So, just breaking it down, the types of provisions: non-competition, non-solicitation, non-recruitment. I'll cover those first three, and then Carl will talk about non-disclosure. So just briefly, for those who maybe aren't as familiar with the new law, it was originally signed into law in April of 2009. Then there was a statewide referendum on an enabling amendment to the Constitution that was passed in 2010. And then because of some issues that I'll talk about in a minute with the effective date, House Bill 30 was signed into law in May of 2011, and the law is codified at OCGA Section 13850. So what the constitutional amendment did is it allows the General Assembly to provide by general law for judicial enforcement of agreements, quote, restricting or regulating competitive activities between employers and employees and other described relationships. One of the things that I think is important to point out is that the amendment does say that it grants to the courts by general law the power to limit the duration, geographic area, and scope of the prohibited activities. Therefore, it would be unconstitutional, essentially, for a judge to expand the duration, geographic area, or scope of a restrictive covenant if it were inclined to do so. The original legislation stated that it was to become effective on the day following the ratification of the proposed constitutional amendment. However, neither the House resolution that proposed the constitutional amendment nor the amendment itself included an effective date, and that led to some problems because there's another part of the Georgia Constitution that had been around for a long time that the legislature, I guess, wasn't familiar with and forgot to read, that says unless the amendment itself or the resolution proposing the amendment shall provide otherwise, it becomes effective on the first day of January following its ratification. Therefore, between November 2nd of 2010 and January 1st of 2011, House Bill 173, which was the original legislation, was arguably unconstitutional as the Constitution had not yet been amended to allow for the legislation. Obviously, this gap was not intended by the legislature, and the timing of the effective date called into question the constitutional foundation of the statute. Arguably, there was an argument that could be made that the amendment couldn't retroactively render the legislation constitutional if it wasn't constitutional at the time it was passed. And so the legislature came back the next session, and in May of 2011, as I indicated, passed House Bill 30, which essentially reenacted the statute itself. and that was intended to cure any problems with the constitutionality of the statute, at least based on the timing issues. So that House Bill 30 says because there may be some question about the validity of the legislation, it's the intention of that act to remove any uncertainty, but it shouldn't be taken as evidence of a legislative determination that it was in fact invalid. So if you have the situation where you have an agreement that was signed after November 3rd of 2010, but before May 10th of 2011, you've got to consider whether that is governed by the old law or the new law. And I think because of 11th Circuit decision, Beckham versus Synthes, the 11th Circuit applied the old law to an agreement that was signed on December 1st of 2010. And the 11th Circuit held that while the original statute was effective on November 3rd, 2010, it was unconstitutional the moment it went into effect because the constitutional amendment was not yet effective, and then the constitutional amendment did not revive the statute. For whatever reason, the 11th Circuit chose to not publish this decision. I suspect it's because they thought that this was an issue that the Georgia Court of Appeals or the Supreme Court should deal with, but that decision is out there, and the Court of Appeals and Supreme Court really haven't directly addressed this issue, although they've addressed it indirectly. So one of the questions is, does it apply retroactively? It does not. The statute specifically says that it only applies to contracts that are entered into on or after the effective date. And there's been several cases, the Cox versus Altus case from the Court of Appeals in 2011, which was dealing with an old law agreement, specifically mentions that and makes it clear that the law does not apply retroactively. So one of the things that I think is somewhat controversial, I had an opportunity to speak at the annual Labor and Employment, the State Bar Labor and Employment Law Institute, or whatever they call it, back in December, and I was asked to talk about the new statute, but specifically about whether there could be a constitutional challenge. And as you may or may not recall, the referendum that we all went to the polls to vote on was, shall the Constitution of Georgia be amended as to make Georgia more economically competitive by authorizing legislation to uphold reasonable competitive agreements? And, you know, that's sort of like asking, are puppies cute? You know, it just obviously suggests a yes answer. I guess I got the reputation of being opposed to the new law when it was being debated down at the General Assembly. I got an opportunity to go down and testify. And I really wasn't opposed to the law. I was just opposed to, I was trying to bring to their attention they really hadn't done their homework, because there is a whole lot of, there are a number of academic studies out there that suggest that greater enforcement of non-competes is not generally good for economic development. And so I was trying to bring those studies to their attention and the various other sort of negative effects that can come from greater enforcement of non-competes. So I like to sort of, you know, take jabs at the statute, take jabs at the folks that were involved in putting it together and passing it. Obviously a lot of hard work went into it and a lot of thought went into it. But I think it was also sort of rigged to make sure that the constitutional amendment got passed so that the legislation would be constitutional. You can see, I guess, looking at the language, after the referendum first took place, but I think it was actually even before the statute went into effect, I had an opportunity to speak at a seminar put on by one of the local accounting firms, and there were about 200 controllers and CFOs and financial types from major corporations in Atlanta and a lot of other companies. And I, you know, did a poll. I said, well, how many folks in this room think that they were voting in favor of greater enforcement of non-competes? And 2 of them raised their hand. So obviously that's anecdotal, that's not empirical evidence, but that was a very intelligent group, a group of folks who probably had a very high percentage of people that went to vote, and they had no idea that they were voting in favor of greater enforcement of non-competes. But, you know, the question is, can it be challenged? And I think, you know, one of the issues is that there is case law that says that the review of ballot language is to be very minimal. In other words, the court is going to look at it and essentially say, is it adequate to enable the voters to ascertain which amendment or what constitutional issue they're voting on. So at least historically, the case law has been very favorable to anybody trying to uphold a constitutional amendment that was enacted through this referendum process. I do think that there are some arguments for why this one's different, and I think it's something that you have to think about. I know that we have a mix of folks in this room, some who work on management side, some who work on the employee side, others who probably do both like I do. But I think that when you're representing an employee, whether individually or, as in my case, most often on behalf of a new employer, you've got to consider whether there is a constitutional challenge and whether that's something you have, an ethical obligation to raise when you're going to court. Certainly the lawyers who are with primarily management side firms, that may be something that isn't politically something that they want to do or something that their clients are going to like if the statute is found unconstitutional. But I think that there are some arguments, and we've made those arguments. I know a couple other lawyers around town who have made them. So far, to my knowledge, there hasn't been any ruling, but it's something that you have to consider. So, here's some sample language from a recent declaratory judgment action. This was not one of ours, but it addresses the question of whether the statute perhaps could be argued to be unconstitutional. In this one, the lawyer is arguing that the language was affirmatively and purposely misleading to the electorate as to exactly what they were voting on and deprived the voters of their due process and other rights guaranteed by the Georgia and U.S. constitutions. There's also some arguments that I've seen that because the statute is vague and ambiguous, that it's unconstitutional. I've not really delved into that argument much. I've seen it made, but I think that, as we'll go through the statute, there are certainly things that you could argue are not that clear and could lead to that argument. I think if you, one of the things that you can look at is if you pull up the legislative history and find the various versions of the proposed referendum, they went through sort of a process of revising the referendum multiple times, and some of the earlier versions, I think, were much more descriptive of actually what was being voted on, and then the one they ultimately settled on is much different from those earlier versions. And I think that the thing that sort of makes this different from the cases that have addressed these referenda in the past is that in the past it was always the legislature sort of modifying or changing powers that it already had, where here the Constitution was very clear that the legislature did not have power to legislate in this area, and that in this case, the legislature took that power, and there's an argument that the cases that have previously scrutinized the ballot referendum should be distinguished on that basis. So let's talk about the statute itself. The first question is, to whom does it apply? The proponents of the bill, one of the things that we'll talk about in a minute when we get to the non-compete part, is they were arguing that what they were trying to do with this statute was make non-competes more enforceable, but make them enforceable to a much narrower group of people. And that the idea was to try to make non-competes illegal or not permissible as to the vast majority of workers. And as we'll talk about, I don't know that that was really accomplished. I think that there is an argument that a much larger percentage of workers are covered by this statute than they led us to believe. But the starting point is, to whom does it apply? And there's this list in 13852. It applies to employers and employees, distributors and manufacturers, lessors and lessees, and you can read the rest. But I think that, experience has now told us that there are some gaps. For example, 13852A6 talks about sellers and purchasers of a business or commercial enterprise. But when you drill down on the definitions, it only applies if someone owns 25% or more of the business. So you've got to contemplate the situation where someone is a minority owner in a business, let's say they own 10%, and they're not an employee in that business, and they have signed some restrictive covenants associated with the sale of that business. What law applies to whether those covenants are enforceable? Under the definitions in this statute, the statute would not apply, in which case you'd have to think about, well, does that mean that the old law applies? And if so, under the old law in the sale of business context, in most situations, the law was pretty clear, but if someone's a minority owner and really didn't have a lot of say in the sale, then perhaps the liberal level of scrutiny that normally would apply to the sale of a business might not apply to that person's restrictive covenant. The other one that I think is potentially not included is contracts between customers and vendors. If you have a client that is a company and they have an agreement with a vendor, and we have this very often where our clients want to include language saying that the vendor's not going to solicit their employees, the vendor's not going to even compete in the business that the customer is in, and the question is whether it would apply in that context. One argument I've heard is that if the customer and the vendor are both employers, then under 13852A7, it's an agreement between two or more employers, so it would be covered by the new law, but I'm not sure that that's crystal clear. And then another one is with former employees. I don't know if Matt Boyd, I don't see Matt, but this was one Matt brought up a number of years ago at the Lorman seminar, is that does the new statute apply to a former employee? So if someone's employment has already been severed and you're negotiating a severance agreement or you're negotiating, sort of post-termination agreement of some sort, and you're going to include restrictive covenants in it, the statute doesn't specifically say that it applies to former employees. It says it applies to employers and employees. So there's certainly a lot for us to argue about and litigate about with the statute, which to me sort of goes back to the issue of whether there's predictability. And I think, like with most legislation, there's going to be plenty of room to disagree. So going back to the definition, to whom does it apply? The first category of people under the definition of employees is executive employees. An executive employee means a member of the board of directors, an officer, a key employee, a manager, or a supervisor. And at least as I understand it, the definition was intended to sort of follow the FLSA scheme with respect to managers and supervisors. So, whether it applies, for example, to the shift supervisor at a McDonald's is something that you probably would have to look to some of the FLSA decisions to make that determination. With regard to officers, for many years we've recommended that clients make employees officers if it's appropriate, because obviously officers have greater fiduciary duties during their employment and then potentially a tail on usurping corporate opportunities after they leave. But all the more so now with the way the statute is worded, if someone's an officer, then they clearly are an executive employee and therefore an employee to whom the statute applies. So the definition of a key employee. A key employee means an employee who, by reason of the employer's investment of time, training, money, trust, exposure to the public, or exposure to customers, vendors, or other business relationships during the course of the employee's employment with the employer, has done one of these things: gained a high level of notoriety, has gained a high level of influence or credibility, or is intimately involved in the planning for or direction of the business. So if someone is not an officer, is not on the board, but falls within the definition of key employee, then they're covered by the statute. A key employee also means an employee in possession of selective or specialized skills, learning, or abilities, or customer contacts or customer information who has obtained such skills, learning, or abilities, or contacts by reason of having worked for the employer. So again, somebody who's sort of developed skills or developed customer contacts or customer information. And I think this is one of the areas where you start to get vague as to, is the receptionist a key employee? If the receptionist has learned who all the customers are and has information about those customers, including their telephone numbers and who they work for and that kind of thing, there's an argument to be made that the receptionist is a key employee. Now, I wouldn't necessarily want to go in front of most of the judges here in Georgia and try to argue that a receptionist is a key employee. It just points out that the definitions certainly leave room for disagreement. So under the statute, an employee also means basically R&D people, people involved in research and development, and that includes independent contractors and those in possession of confidential information that is important to the business of the employer. An employee also means any other person or entity, including an independent contractor in possession of selective or specialized skills, learning, or abilities, sort of this same language. But in this one, in C, it says by reason of having worked for an employer. And I guess if we go back to this language in 13851.8, it says by reason of having worked for the employer, where here it says by reason of having worked for an employer. I'm not sure whether that difference was intended, but it is a slight difference, and someone could argue that even skills that were learned at a prior employer, if those skills were then used at the next employer who's trying to enforce the covenant, that perhaps this part, 13851.5c, applies regardless of whether those skills were learned from the employer that's seeking to enforce the covenant. One that we've come across recently is a loan underwriter at a bank. Someone who is working at a bank who's underwriting loans for mortgages or other types of loans, is that person an employee within these definitions? That individual generally has minimal client interaction, doesn't participate in sales. That person certainly has confidential information about the customer. So there's an argument to be made that perhaps under these definitions, because he or she has confidential information, he's covered by the statute, but I believe that the statute is intended to talk about confidential information of the employer, not of the employer's customers. So I think that there are various types of employees out there where there's some ambiguity as to whether the statute would apply to them. Another issue is, can the employee argue that he or she is not an employee because under C, because he already possessed the selective or specialized skills, learning, or abilities or customer information before coming to work for the employer. And I think that's where that sort of difference between having worked for an employer or the employer comes in. So then the next question is, who is excluded? Because as I said, the intent was to exclude what was supposed to be the vast majority of workers. So the statute says an employee shall not include any employee who lacks selective or specialized skills, learning, or abilities. So this is just sort of the mirror image of the definition we were just looking at. So it says that non-competes, now this doesn't apply to non-solicitation covenants, non-recruitment covenants, non-disclosure covenants, only with respect to non-competes, shall not be permitted against any employee who does not do one of the following things: customarily and regularly solicit for the employer customers or prospective employers, so somebody who's basically a salesperson out there selling; customarily and regularly engage in making sales or obtaining orders or contracts for products or services to be performed by others, which is essentially, again, another sales person. Or perform the following duties: have a primary duty of managing the enterprise in which the employee is employed, so someone that's a CEO, someone in senior management who has the primary duty of managing the enterprise, someone who customarily and regularly directs the work. These are, again, sort of very similar to the FLSA definitions. And then having the authority to hire or fire. And then people are also excluded from being subject to non-competes if they perform the duties of a key employee or a professional. And we talked earlier about what the definition of key employee is and the definition of professional is in the statute. So, really, if you look at this, arguably, it is a narrower definition or a narrower group of people to whom non-competes, for whom non-competes are permitted under the new law. And I think that, whether somebody regularly solicits customers, whether someone is regularly engaged in making sales, whether someone's in management, those are the things really to look at when you're analyzing whether someone really can be subject to a non-compete, both when you're drafting them and then if you're in a situation when you're analyzing whether you can pursue somebody on behalf of an employer or if you're defending the employee, whether the non-compete is permissible. Yes?
Jen, do you think a person at a call center at Amazon whose job is regularly to take orders over the phone or any other sort of direct marketing firm, who that's what their job is to answer the phone and take orders from people, are they going to be covered?
Well, if you look at, I'm sorry, so yeah, I've got to repeat the question. The question is, would somebody taking orders at Amazon in a call center come within this definition? And I think it's a good question. I think I could certainly argue that right there under 13853A2, that person is customarily and regularly engaging in making sales or obtaining orders. So those are incoming calls. They don't necessarily have to be out soliciting and doing sales. And so I think that there is an argument that person is covered under the statute, which goes to my point earlier that I think a much wider group of folks are covered by the statute than the proponents wanted us to believe. So, that's sort of the basic framework of who's covered. And then there are other things that are discussed in the statute. The first is that in order to enforce a restrictive covenant, a non-compete or non-solicit or non-recruitment, you have to plead and prove the existence of one or more legitimate business interests. I guess the statute makes it easy to do that. So a legitimate business interest includes but is not limited to trade secrets as defined under the trade secret statute, valuable confidential information that otherwise does not qualify as a trade secret, substantial relationships with specific prospective or existing customers, patients, vendors, or clients, customer, patient, or goodwill associated with any of these things, extraordinary or specialized training. So, the one thing you have to keep in mind is when you're drafting the complaint, if you're going to try to enforce a covenant, is to be sure to put this in the complaint, because if you don't, then it is subject to a motion to dismiss. Now, likelihood is the judge will allow you to amend, but it just makes it look like you know what you're doing a lot more if you've got it in your complaint initially. And then the other thing is, in drafting these agreements, I think it is, at least what we've been doing, is identifying these right in the preamble to the agreement, in the whereas clauses, whatever it is, and having the employee acknowledge that each of these things are legitimate business interests that the employer is seeking to protect. We're also including the language from the definitions that I just went through as to who's covered, so that where the employee is actually acknowledging that he or she is doing the things that would bring them within the definition of employee. I think it makes it a lot easier when you go into court to be able to say, well, they're arguing, Judge, I didn't fall within this statute, and at least as an initial argument you can say, hey, Judge, when they signed this agreement, they acknowledged that they were in fact covered and that they were doing the things that the statute contemplates. On the legitimate business interest, it's funny because the statute sort of has, throughout you can see where they just tried to address specific issues that had been addressed in case law under the old law. Kevin Levitas was one of the representatives who was the primary proponent of this legislation. And I got to know Kevin through this process, and it turns out he lives down the street from me. And I love to, sort of rib him about things. But I don't know if you all remember the case under the old law where there was a physician who had passed away, and he had a non-compete with another physician in his office. And the widow tried to enforce the non-compete, and the court wouldn't enforce it because it found that the widow couldn't engage in the practice of medicine, and therefore she had no legitimate business interest in the business trying to enforce the non-compete. So this part is intended to address that type of scenario where it's not a defense that the person seeking enforcement no longer continues in business in the scope of the prohibited activities that's the subject of the action. And there could be other situations where that might apply. For example, if you have a client that has some business unit, they decide to shut that business unit down or stop selling a particular product or service, yet they still want to enforce a non-compete related to that because they may get into it later. There may be other legitimate reasons why they want to do that. This part of the statute makes it clear that the fact that they're no longer in that business does not automatically render it unenforceable. The statute lays out various presumptions relating to time limitations. So with respect to post-termination covenants, in the case of a former employee, any restraint 2 years and less in duration is presumed reasonable, but a restraint more than 2 years in duration is presumed unreasonable. In some of the other contexts, distributors, dealers, franchisees, lessees of real estate or personal property, licensees of a trademark, trade dress, those kinds of things, 3 years is presumed reasonable, and then anything more than 3 years is presumed unreasonable. And then in the sale of business context, essentially in the case of restrictive covenants sought to be enforced against the owner or seller of all or material part of the assets of a business, the shares of a corporation, a partnership interest, etc., a restraint of longer than 5 years is presumed unreasonable, and then one that is, or one equal to the period of time during which payments are being made. So if there's a buyout or a payout or an earn-out in the sale, then if that goes longer than 5 years, then the non-compete can extend beyond 5 years. The thing that's curious to me about this is that this actually represents a limitation on non-competes in the sale of business context. Under the old law, you could have a non-compete that extended as long as the buyer continued in the business. But now, under this statute, you're limited to 5 years, which, there's some business lawyers I know who are in the room. It seems to me that, if you've got a client that's buying a business and the best they can do is restrict the principals for that business from competing for 5 years, that's going to impact the purchase price. And so I don't know why the legislature chose to put a limitation on non-competes in the sale of business context, but I think it's one that's important to be aware of and make sure that clients are aware of when they're thinking about selling a business. So on the territorial restrictions, again, these only really come into play in the non-compete context. And basically, I could read all of the language, but at the end of the day, what the legislature tried to do was essentially make it an anything goes and leave it up to the judge to decide what's reasonable. So you don't have to, as under the old law, you had the employee at the time he or she signed the agreement had to know the geographic extent of the restriction. You couldn't have a geographic territory that was defined by the territory they were working at the end of their employment, or that would somehow shift or change or expand during employment. And the statute makes it clear that under the new law you can, and that you can define in the agreement the territory that the person was working in at the end of his or her employment as the territory that is the applicable territory for the non-compete. And the statute instructs the judge essentially to construe it to only cover so much of such estimate as relates to the geographic area actually involved. So, under the old law, if you sort of made a mistake or if you were too broad on the territory, your covenant was just going to be struck down. Where here, what the judge is supposed to do is construe it only to be the territory in which the employee is actually involved at the end of his or her employment.
Well, that was my question. Is it the employee's involvement, or is it where the business conducts its activity?
Well, I think there's other parts of the statute that essentially allow it to go to the extent of where the employer's business is, not where the employee is working for or representing the employer as under the old law. So that part of the statute isn't that clear on that, but I think other parts that we'll talk about make it clear you can go to the extent of the employer's operations. Now, that said, as a practical matter, my experience has been that judges aren't generally going to allow that unless there's a really good reason. I mean, if there's some trade secret, something that's really valuable that an employee has that would make, for example, a nationwide non-compete reasonable, then perhaps the judge is going to enforce that. But if you've got your average sales guy that is, his territory is the Southeast, and you've got a nationwide non-compete, I think it's unlikely that most judges are going to prohibit that person from working nationwide. You know, I've got a biotech client we do a lot of work for, a lot of trade secrets and confidential information disputes, and you know, they have things, it's not quite the Coke formula, but it's very similar to the Coke formula. They've got procedures and protocols and things in their manufacturing process that they keep highly confidential, that are very secret. And I think in that context, having a nationwide non-compete, for example, I can explain to a judge why it makes no difference if this person is here in Atlanta or this person moves to Boston or Silicon Valley or whatever, that a nationwide non-compete is reasonable because you're trying to protect that trade secret. But if all you're trying to protect is customer relationships in a particular area, I think that it's going to be much more difficult to go beyond the area in which the employee is working for or representing the employer.
You're working on the internet. You're selling over the internet.
Right.
Where there is no. I mean, you're all over the world.
Well, and I think that's, I guess the question, I'm supposed to repeat the question. The question is, if you're working on the internet, you may have a worldwide reach, but to me, again, I think a judge is going to look at that and say, well, really, is a worldwide or even a nationwide non-compete appropriate if somebody is, you know, sitting here in Atlanta, for example, and dealing with customers all over the country or all over the world in a particular business. And I think that's something that, you know, it's yet to be seen. We just don't know, for example, what the Court of Appeals or the Supreme Court would do with that.
And also in that circumstance, it's so factually dependent. Because
Right.
people say that all the time, but did he really sell in France, or did he really sell in Spain, or when you say all over the world? Potentially they could go all over the world, but the court may look at
All over
what...
the nation, I think, is a much more reasonable interpretation.
Well, that's possible, but when you actually look at it, you actually look and see, did the employee really sell in Oregon, for example? Many times it's not in every state, although they could conceivably be in any state. The judge may look at where the sales actually did take place.
Yeah, I think that's
You know?
true. And, you know, we've done that. We've, you know, gone into court and plotted on a map where all the customers are and said to the judge, look, judge, you know, this is the area where this person's customers came from that they dealt with, and this is the area you should join them in. And I think most judges, you know, again, it just depends on the judge. Some of the older judges, I think, are still sort of the mindset that they shouldn't enforce non-competes, and they don't like them. And then, you know, some of the newer judges tend to sort of not, if they didn't do this work in practice, sort of look at the statute and try to figure out what the statute permits them to do. So, you know, on the definition of territory, the discussion of territory, like I was saying, the phrase "the territory where the employee is working at the time of termination" or similar language is considered sufficient as a description of the geographic area if the person or entity bound by the restraint can reasonably determine the maximum reasonable scope of the restraint at the time of termination. So it takes away that issue that you had on the front end under the old law. Then there's this other provision, 13856-2, that talks about essentially a couple of things related to territory. One is that the total distance encompassed by the provision is reasonable. If it basically includes the area in which the employer does business at any time during the party's commercial relationship, even if not known at the time of entry into the covenant. Now, again, what does that mean? To me, that means that, again, it's entirely up to the judge to sort of look at the history of the relationship and decide what the judge considers to be reasonable. Because on the one hand, it's saying, you know, as long as it includes the area in which the employer does business, but that the total distance encompassed is reasonable. I don't know what that means. That means whatever the judge thinks it means. But then there's also this provision about listing competitors. The agreement contains a list of particular competitors as prohibited employers for a limited period of time after the termination of employment. I don't know why they chose to include a limited period of time in that definition, given that you have the presumptions. So I don't know if that means that has to be less than 2 years, for example, in a employment context, or whether that's just referring back to the presumption related to 2 years. I still think if you're going to draft an agreement that has a list of competitors it's best to include a territory and have some rationale for that territory, whether that's the area in which the employer is doing business, or, at least for me, preferably where the employee really is doing business. Because I think at the end of the day, when you're in front of a judge, trying to convince the judge to enjoin somebody from competing anywhere where the employer does business is going to be very difficult. So now with regard to activities, products, or services under the old law, you had to have a defined territorial scope, territorial limitation. You had to have a defined scope. What are the activities the person's prohibited from engaging in? What were the products, the services? And so what the statute does is everything we've just been talking about with respect to territory does the same thing with respect to activities, products, or services. So you don't have to define them on the front end. Essentially, it's going to allow the judge to look at, okay, what was this person selling? What product or service was this person involved with at the time of the termination of his employment, his or her employment, and prohibit the person from competing in that area. If you have a client that has multiple business units that sell different types of products and services, then there's a decent chance a judge is not going to keep the person from doing anything that the employer does, probably only going to prohibit the employee from doing what selling what he or she sold for the employer. So the statutory language here is basically the same. Again, in determining the reasonableness, the court is supposed to presume that the scope of competition restricted is measured by the business of the employer. That may go contrary to what I just said. I think that theoretically, if you have multiple products and services, but someone's only involved in one, theoretically under the statute, you could prohibit the person from selling or being involved in the sale or manufacture of any of those products or services. But I think as a practical matter, getting in front of a judge and trying to convince the judge of that is going to be difficult unless someone is a C-level executive or a very senior executive who has information about all of the business units that would be valuable to him or her in competing. Just briefly on in-term covenants, basically again this addressed what was then the Atlanta Bread Company issue, where the court had held a in-term covenant unenforceable because it did not have a territorial scope and a scope like a post-termination covenant. I guess I don't like to publicize it, but I, in the last year, lost a decision at the Court of Appeals where we had an agreement under the old law that said that this person was an independent contractor, but the person would devote her full working time to the employer. And it's the Memedex case. It's in your materials. The Court of Appeals found that that was an unenforceable non-compete, that because it just said full working time and it didn't have a territory and it didn't have a scope, that it was unenforceable. So essentially took the Atlanta Bread Company case and expanded on it. And I think it was a terrible decision because I lost, but that's the law under the old agreements. And so I think one of the things to look at is if you have a case involving an old agreement where the court can't blue pencil, that if you have an in-term provision like that says something like devoting full working time or will not do anything for a competitor during the term of employment, not only is that covenant potentially unenforceable, but then it can render all of the post-termination covenants unenforceable because the court can't sever them. So here again on in-term covenants, they're not unenforceable because they lack a time limit, a geographic limitation or any limitation on the activity's scope or product or things of that nature. So now the statute also specifically deals with non-solicitation provisions, and I think the thing to be aware of here is that as to non-solicitation covenants, the statute really didn't change the law at all. So non-solicit covenants still have to be limited to those customers with whom the employee had material contact if there is no territorial limitation. Now, the way they made it easier is that material contact has a much broader definition than that it did under the old law. Under the old law, the employee actually had to have some contact with the customer, where here, under the statute, material contact is defined as those with whom the employee dealt, but also whose dealings were coordinated or supervised by the employee, or about whom the employee obtained confidential information. So in that example, again, that's one of those where they specifically went after one of the decisions under the old law, the Trujillo case. The Trujillo case said that prohibiting somebody from soliciting customers about whom he or she obtained confidential information without a territorial limitation was unenforceable if that person didn't have actual contact with the customer. So the statute has changed that. And then you want to look at that Part D. I won't read the whole thing, but essentially if someone receives compensation as a result of sales to certain customers, then those customers are considered customers with whom he or she had material contact. It does not appear that the new statute has changed the rule with respect to acceptance of unsolicited business. Yes?
Case of C on the preceding slide, you have executives and others who have access to all the records and effectively have information confidential or enforced about the entire client base. How do you reasonably enforce that? One, the former employee may not have material contact because the fact knows what they pay. Other issues, when they leave, how do they even know who they're prohibited from soliciting?
It's a great question. The question is, if you have a situation where you have a senior level person who has information about all of the customers, confidential or trade secret information about all of the customers, as a practical matter, you prohibit that person from soliciting any of the customers, and if so, how does the employee know who he or she is prohibited from soliciting? And I think that is a challenge. I think that the statute certainly is directly addressing that issue and allows for it, but as a practical matter, when you're in front of a judge, I think a judge is going to ask that question and say, well, how does he know? If it's one thing if the business has, 10 or 15 or even 50 customers. It's another thing if the business has 1,000 customers. How's the employee supposed to know whether he or she is allowed to solicit? I think that's hard.
Well, I
Mark?
think one way is you have to say, you have to prove that they obtained information, not that they had access to it, but that somehow they obtained it. So who knows what affect that?
Yeah, that's a good point, that you have to show that they obtained confidential information, not just had access to it. I'm running out of time, and I do want to get through a few other things, so we're going to have a question and answer session, I think at the end, from the very end of the seminar from 2:30 to 3, so if you could hold your questions till then, or the rest of the questions till then, that would be great. Under the old law, you couldn't prohibit acceptance of unsolicited business, and I think that's still true under the new law, absent a territorial restriction. And then even with the territorial restriction, there's a question of whether that would be an enforceable covenant or not. Presumably, under the new law, the court could blue pencil out the language regarding acceptance of unsolicited business, so if you include that language, it shouldn't be fatal like it was under the old law. The question is, does the new law cover does the new law cover non-recruitment covenants? And if you look at the definition of restrictive covenant in 13.851.15, it says an agreement between two or more parties that exist to protect the first party or party's interest in these various things, and it includes employees. So the question is, does that mean that non-recruitment provisions must comply with the rules set out in the statute? If so, then potentially under this statute, the rules with respect to non-recruitment covenants are stricter than they were under the old law. Under the old law, the cases were sort of all over the place, but generally there was at least a good argument you didn't need a territorial restriction. Where here, under the new statute, subject to all the things we said about how broad that territory can be, there's an argument to be made that you have to have a territorial restriction in order for the non-recruitment covenant to be enforceable. Burden of proof, I'll skip through this real quick. It's all in the statute. On the defenses, the one that I like to talk about just briefly is the economic hardship defense. I think that's one that, for example, in Florida, the statute in Florida specifically says the courts cannot consider any economic hardship that would result from the enforcement of the covenant. But our statute does provide for that defense. I think the thing you've got to think about, though, if you're representing an employee in asserting that defense is, does that open up all of your clients' finances to discovery? How many big screen TVs do they have in the basement? How many luxury vacations have they taken in the last year? What really is the economic hardship? Especially if you have sort of the mid-level salesperson who's making maybe $100,000, $150,000 a year, but is spending it all, and then asking the judge to enjoin that person, and the person comes back and says, well, Judge, if you enjoin me, I can't earn a living. Are you opening the client up to discovery about everything that they're, all of their assets and what they're spending and that kind of thing? So blue penciling or judicial modification, I guess the question is which the statute provides for. In this section, it says a court may modify the covenant as long as the modification doesn't render it more restrictive. In this other section, I don't know why they chose to repeat it, but the court may modify the restraint, so it is not mandatory. Again, in Florida, for example, it's mandatory that the court modify the covenant if it finds it's overbroad. Here, it's discretionary whether the court should do that. And then the definition of modification means the limitation of a restricted covenant to render it reasonable in light of the circumstances in which it was made. Such terms shall include severing or removing that part of a covenant that would otherwise make the entire covenant unenforceable, and then B, enforcing the provision of a restrictive covenant to the extent that the provisions are reasonable. So the question is, by saying such terms shall include, is that inclusive or exclusive? There's actually some case law not having to do anything to do with non-competes that has to do with the anti-SLAPP statute. And there's a case, the Berryhill case, that is addressing that the anti-SLAPP statute. And in that case, the Georgia Supreme Court says that include is exclusive when you have something like this, because it doesn't say such terms shall include without limitation or shall include among other things. It just says include, which means that, at least under the Berryhill case, it's limited to these two things. It doesn't mean that these are just two examples of what the court can do. If that's the case, then it's a blue pencil statute. It means the court can only strike the offensive provisions. If it's not, and the court can judicially modify the agreement to basically do what the judge thinks is reasonable without having to just use the blue pencil to strike the offensive provisions, then that's a big difference in the way in which the law is going to be applied, and it's yet to be seen which way the courts are going to go on that. Unfortunately, we, like I said, don't have any decisions from the appellate court, the Georgia appellate courts, but Judge Story's decision in the Zander case, it goes back to 2011 now, but that's a good example of blue penciling. I think actually in that case the judge judicially modified the covenant, so at least Judge Story thinks that that's what we're permitted to do. But in that case, the covenant prohibited soliciting or accepting competitive business from any of the employer's clients with whom the employee had contact or who were clients of the employer within 3 months immediately preceding termination of the agreement. The court found the covenants were overbroad because they extend to any of the employer's clients, not just those with whom the defendant interacted. And so Judge Story enjoined the defendant from soliciting any customers with whom the defendant had contact during her employment. Again, there was no mention of blue penciling the acceptance language out, but the injunction did not prohibit acceptance. Consideration under the old law, continued employment with sufficient consideration, and it does not appear that that has changed under the new statute. Same with writing. There's nothing under the new law that suggests that a restrictive covenant doesn't have to be in writing. Tolling, the new statute doesn't address tolling. Under the old law, you could toll the the duration of the covenant during any period of litigation, but you couldn't toll it during any period of breach. And so it's yet to be seen what the courts are going to do with that. I suspect that the law will just remain the same, and if you have a provision, a tolling provision that it tolls it during any breach, that the court can just blue pencil or modify that out, unlike before where that could invalidate all of the covenants. Sale of business, I'll let you look at the materials for that because I'm out of time. And then last, I always love to finish with this. For lawyers, we're different. As everyone hopefully knows, that Rule 5.6 of the Georgia Rules of Professional Conduct prohibits us from entering into non-competes with our associates, our lawyers in our firm. The thing that's funny to me about that is that the rationale is that the public should have the absolute right to choose his or her lawyer, yet in Georgia, obviously non-competes are completely enforceable with respect to physicians. So it's important that we be able to choose our lawyer, but not necessarily our physician. So that's all I've got. I appreciate your attention.